My name is Ala Suhaila. My metric number is 20DA323F1001.
Hi, my name is Naim Ataullah bin Sharif. My metric number is 20DA323F1051.
Hi, my name is Kausalena Seda Anapilosaw. My number matrix is 20DAT23F1049.
Hello, my name is Muhammad Fikri Nuriman bin Azari. My matrix number is 200DA23F1021. And I'm the fourth presenter.
Hi, my name is Muhammad Zilazi bin Zamri. I'm from class DAT3A and my metric number is 20DAT23F1033.
Tradex Sdn Berhad has decided to cease its operation under Section 439 Subsection 1 of the Companies Act 2016 as the period fixed by the company for the duration of the company had expired. The company then passed resolutions for a members voluntarily winding up MVWU and appointment of Sarah as an interim liquidator. However, it was barely 7 days later than company found that the declaration of solvency had been duly negligently prepared where it involved a serious miscalculation. In fact, there are still several liabilities to creditors which are unable to be settled by the company within a 12-month period.
In the meantime, Sarah has also discovered several misappropriate transactions of a Tradex Berhad funds accounting 750,000 ringgit into the company managing director personal accounting since the past 3 years. In surprise, there are also several assets and a property of the company which has been misused by a majority of executive director. Advise Sarah on whether she has a locus standi and can apply for a winding up by the court based on the above reason.
Definition of winding up. Winding up is a process in which the existence of a company is brought to an end, in which assets of a company are collected and realized. The process collected are used to discharge the company's debt and liabilities, and the remaining balance, if any, will be distributed among the contributors according to their entitlement. For the first issue of the case is whether Tradex Berhad can use the context of members voluntary winding up MVWU and the provision under the case section 439 subsection 1 of Companies Act. A company will be wound up voluntarily when the period, if any, occurs on the occurrence of which the Constitution provides that the company is to be dissolved and the company's general meeting has passed a resolution requiring company to be wound up voluntarily. Next, provision under the case section 443 declaration of solvency subsection 1, where it is proposed to wind up a company voluntarily, the director, or in the case of a company having more than one director, the majority of the directors may, subsection A, make a written declaration to the effect that the directors have made an inquiry into the affairs of the company, and subsection B, at a meeting of directors have formed the opinion that the company will be able to pay its debt in full within a period not exceeding 12 months after the commencement of the winding up. For the case is Sri Hari Simons Construction Limited 1989. Hari Simons Construction Limited was a building company. From April 1985 to 1988, its turnover increased from $830,000 to $27 million. It all came from one client called Berkeley House Peak. They had a close relationship, but it went sour, and Berkeley prepared to dismiss them. It withheld several millions pounds in payment. Harry Simons could not pay debts as they fell due or carrying on trading. The report of the proposed administrator said it would be very difficult to sell any part of the business. Berkeley said if an administration order were made, it would give enough funding to let the company complete 4 contracts on condition it remove itself from the sites that were in dispute. For the conclusion of the case, held, Tradex Berhad cannot use the context of MVWU members voluntary winding up. According to Section 439 Subsection 1 of Companies Act 2016, the company period fixed by the company head expires. Then, according to Section 443 Subsection 1 Subsection B, the company will be able to pay its debt in full within a period not exceeding 12 months after the commencement of the winding up, but Tradex Berhad failed to do so because there are still several liabilities to creditors which are unable to be settled by the company within the 12 months period.
Issue of the case. Second issue of the case is whether Sarah has a locus standi and can apply for winding up by the court. Provisions under this case, Section 464, Subsection 1, Subsection D, Company Act 2016. Subsection 1, a company whether or not it is a begin winding up voluntarily may be wind ups under an order of the court on the petitions of any one or more of the following. Subsection D, the liquidator. Provisions under case Section 465, Section 1, Subsection E, Company Act 2016. Subsection 1, the court may order a winding up if Subsection E, the company is unable to pay its debt. Section 465, Subsection 1, Subsection F, Company Act 2016, the court may order a winding up if Subsection F, the director has an act in the affairs of the company in the director's own interest, that is the interest of the members as a whole of act in any other manner which appears to be unfair or unjust to the member. Conclusions of the case held Sarah has a locus standi according to sections 464 Subsection 1 Subsection D Company Act 2016 because she is a liquidator. She has a right to appear and to be heard before a court. According to sections 465 Subsection 1 Subsection E of a Company Act 2016, circumstances in which company may be wound up by a court is when the company is unable to pay its debts, which there are still several liabilities to a creditor which are unable to be settled by the company within 12-month period. There is also a conflict of or interest which misappropriate transactions of a trading Sandian Berhad fund amount 750,000 ringgit into a company managing director personal's amount since the past 3 years. In applying for a section 465 section 1 section F of a Company Act 2016.
Question 2. Amar and Reza, two of the shareholder and director, Paris Holding Berhad opted not to take any dividend but only to receive their monthly salary. Reza's wife Liana then joined the company as a shareholder and director, and both the husband and wife now take control of the company. Since there had been several major disagreements between Amar and the couples on the company director, and their relationship had worsened and deteriorated from time to time. Having lost their parties, Reza and Liana had passed a resolution to terminate Amar, discuss him lost source of income. With utter dissatisfaction and disappointment, Amar had petitioned and granted a compulsory winding up order by the court. Acted as a liquidator, Azlan is required to ensure that the company's properties and being located used to discharge company liabilities and distribute amount contribution, if any. Since the winding up order was obtained He had first settled the creditor's claim prior to the legal dividend to creditors, whether the federal tax and company contracts without knowing any of their purpose and right-ranking of distribution. Davis examined on his power and whether he had discharged his right duties. Issue first, whether Reza and Diana act of excluding Amar from management constitutes opposition or affair produced toward him as a shareholder and director. And second, whether Amar was justified in filing and compulsory winding up petition under the just and equitable ground. According to Section 465, Subsection 1 H of the Company Act 2016, the court is of the opinion that is just and equitable that the company the warm up as long as for local standing, because according to Section 464 Subsection 1 E, a contributory or any person who is the personal representative of a discrete contributory or the trusted in bankruptcy of the Director General of the Solvency of the statute of the bankrupt contributory.
So next is case Ibrahimi versus Westbourne Galleries LTS 1973 SC360. For the facts, the company consists of the two shareholders, Naza and Ibrahimi. Both of them are the shareholders and directors of the company. They were not paid any dividends, received wages from their service. Later, Nazar's sons joins the company as a shareholder director, and now father and son control the company. To terminate Ibrahimi, which caused a loss of income, Ibrahimi made a petition to wind up the company. It was held that when Ibrahimi and Nazar set up the company, it is on the basis that the nature of their relationship would remain the same, despite the fact what the Nazar did was perfectly legal. It was just and equitable that the company be wound up. So next, for issue, it is just equitable to wind up a company that is a quasi-partnership if there has been a breakdown in the mutual trust and confidence that should exist among shareholders. For the court ruling, the House of Lords upheld an court order winding up the company on the just and equitable ground. The House of the Lords held that even through the applicable Companies Act, an article may allow for a particular cause of action, as the removal of a director, where the company was in substance a quasi-partnership. The majority shareholder had to act in the way that was consistent with the understanding the shareholder had at the time the company was formed. This understanding involved mutual confidence. It was appropriate in the case to order a winding up because this understanding had been repudiated. The minority shareholder excluded from management of the affairs of the company, and he lost his right to share means profits.
For application to the case, in this situation, the relationship among shareholders and directors significantly deteriorated. leading to disputes over the company's direction. Reza and Iana's action, including terminating Amar's role and potentially excluding him from decision-making, may constitute oppressive behavior. The breakdown of trust and confidence is evident, and it appears that the company can no longer be operated in line with its intended objective or in the best interest of all parties. The court, in applying Section 465, subsection 1, subsection H, may consider Amar's termination and exclusion from control as sufficient justification for winding up on just and equitable grounds. When a company is essentially a quasi-partnership where mutual trust and confidence are key, action that disrupt this balance, such as exclusion from management, can lead to a winding up order under this section. Conclusion to the case: the court granted a compulsory winding up order based on Section 465, subsection 1, subsection H of the Companies Act 2016, likely due to the irreparable breakdown of trust and confidence between Amar and the controlling parties, Reza and Liana. Given that the relationship among key shareholders had deteriorated beyond repair, it was just and equitable for the company to be wound up.